ಅವಳು ಹೇಳ್ತಾಳೆ, ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟವರು, ನನ್ನ ಮಗಳಾದ ಶ್ಯಾಮಲಾಬಾಯಿ ಗಂಡ ಬಸವರಾಜ್ ಕಟ್ಟಿಮನಿ ಇಸ್ ದ ಅಪೆಲೆಂಟ್ ಹಿಯರ್. ಇವಳಿಗೆ ಅತ್ಯಾಚಾರ ಮಾಡಿ ಕೊಲೆ ಮಾಡಿದವರ ಮೇಲೆ ಕಾನೂನು ಕ್ರಮ ಜರುಗಿಸುವ ಬಗ್ಗೆ ಅರ್ಜಿ. ಮಾನ್ಯರೇ, ನಾನು ನಿಲ್ಲಮ್ಮ ಗಂಡ ಮರೆಪ್ಪ ಬುದಿ, ವಯಸ್ಸು 55, ಜಾತಿ ತಳವಾರ್, ಹೊಲ ಮನೆ ಕೆಲಸ ಮಾಡ್ಕೊಂಡು ಬದುಕ್ತಿದ್ದು. ಈ ಮೂಲಕ ನನಗೆ 3 ಜನ ಗಂಡು ಮಕ್ಕಳು 2 ಹೆಣ್ಣು ಮಕ್ಕಳು ಇದ್ದು, ಅದರಲ್ಲಿ ಶ್ಯಾಮಲಾಬಾಯಿ ಹಿರಿಯ ಮಗಳಿದ್ದು, ಅವಳಿಗೆ ಸುಮಾರು 20 ವರ್ಷಗಳ ಹಿಂದೆ, ಅಂದ್ರೆ ದೇ ಮ್ಯಾರಿಡ್ ಫಾರ್ 20 years ಹಿಂದೆ ಬಂದರವಾಡ ಗ್ರಾಮ ಬಸವರಾಜ್ ತಂದೆ ಹಿರಿಗಪ್ಪ ಕಟ್ನಿ ಇವರೊಂದಿಗೆ ಮದುವೆ ಮಾಡಿ ಕೊಟ್ಟಿದ್ದು. ಸದ್ಯ ನನ್ನ ಮಗಳಿಗೆ ವೀರೇಶ್ 19, ಮಹೇಶ್ 16 ಮತ್ತು ಭಾಗ್ಯಶ್ರೀ ಅಂತ ಮಗಳು 17 ವರ್ಷ. ನನ್ನ ಮಗಳು ಗಂಡ ಮಕ್ಕಳೊಂದಿಗೆ ಹೊಲ ಮನೆ ಕೆಲಸ ಮಾಡಿಕೊಂಡು ಸಂತೋಷದಿಂದ ಇರುತ್ತಾಳೆ. ದಿಸ್ ಇಸ್ ವೆರಿ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್. This woman on the date of complaint saying that from 20 years my daughter was married, she is having 3 grown-up children and she was living happily. So my lords, the question of strained relationship absolutely doesn't arise. If you see the title of Vishaya, the body was found in a village, in a land, in such a state where it appears either she was raped or there was an attempt to rape. In such state of affairs, the body was found and then her head was smashed. And this particular, and come, if you see the next page, my lords, last page, the next, ಅಲ್ಲಿ ಇವರ ಪಾಲಿಕೆ ಮಾಡಿದ ಮಹಾದೇವಪ್ಪ ಹೊಲದಲ್ಲಿ, ಐ ಆಮ್ ರೀಡಿಂಗ್ ಆನ್ ದ, ಐ ಆಮ್ ಕಂಟಿನ್ಯೂಷನ್. ಲಕ್ಷ್ಮೀ ಭೂದಿತನ ಫೋನ್ ಮಾಡಿ ಹೇಳಿದ್ದೇನೆಂದ್ರೆ, ಅಲ್ಲಿ ಐ ಆಮ್ ರೀಡಿಂಗ್ ದ ಫಸ್ಟ್ ಲೈನ್. ಇವರ ಪಾಲಿಗೆ ಮಾಡಿದ ಮಹಾದೇವಪ್ಪ ಹಾಲಿಯವರ ಹೊಲದಲ್ಲಿ ಶ್ಯಾಮಲಾಬಾಯಿ ಅಕ್ಕ ಇವರು ಗೋಧಿ ಬೆಳೆಗೆ ನೀರು ಬಿಡಲು ಹೋದಾಗ ಯಾರೋ ದುಷ್ಕರ್ಮಿಗಳು ಅವರ ಮೈ ಮೇಲಿನ ಬಟ್ಟೆ ಬಿಚ್ಚಿ ಅತ್ಯಾಚಾರ ಮಾಡಿ ಮುಖ ಮತ್ತು ತಲೆಯ ಮೇಲೆ ಕಲ್ಲು ಎತ್ತಿ ಹಾಕಿ ಕೊಲೆ ಮಾಡಿರ್ತಾರೆ ಅಂತ ಹೇಳಿದ್ರಿಂದ, ನಾನು ನನ್ನ ಗಂಡ ಮರೆಪ್ಪ, ಮಕ್ಕಳಾದ ಭೀಮಾಶಂಕರ, ಶಿವಪ್ಪ, ಶರಣಬಸು ಕೂಡಿ ಬಂದರವಾಡ ಗ್ರಾಮದ ಮಹಾದೇವಪ್ಪ ಹಾಲಿಯವರ ಹೊಲದಲ್ಲಿ ಬಂದು ನೋಡಲಾಗಿ ನನ್ನ ಮಗಳ ಮೈ ಮೇಲಿನ ಅರ್ಧಂಬರ್ಧ ಬಟ್ಟೆ ಬಿಚ್ಚಿ ತಲೆಯ ಮೇಲೆ ಕಲ್ಲು ಎತ್ತಿ ಹಾಕಿ ಮಾಡಿದ್ದು ಇತ್ತು. ಅಲ್ಲಿ ಹಾಜರಿದ್ದ ನನ್ನ ಅಳಿಯ ಬಸವರಾಜ್ ಕಟ್ಟಿಮನಿ. ಸೊ ದ ಅಳಿಯ ವಾಸ್ ಆಲ್ಸೋ ಪ್ರೆಸೆಂಟ್ ದೇರ್. ಕಟ್ಟಿಮನಿ, ವೀರೇಶ್, ಮಹೇಶ್ ಸಂಬಂಧಿಕರು ಕರಬಸಪ್ಪ, ವಿನಾಯಕ್, ಅಲ್ಲೂರ್ ಇವರು ಹಾಜರಿದ್ದು. ವಿಚಾರಿಸಲಾಗಿ ನನ್ನ ಮಗಳು ಬೆಳಿಗ್ಗೆ 10 ಗಂಟೆಗೆ ಹಿಂಗ್ ಹೋಗಿದ್ದಾಳೆ, ಅಲ್ಲಿ ಏನೋ ಯಾರು ಈ ತರ ಮಾಡಿದ್ದಾರೆ ಅಂತ. ದಿಸ್ ಇಸ್ ದ ಕಂಪ್ಲೇಂಟ್, my lords. Subsequently, prosecution, instead of investigating who has committed this offense, they have turned the entire case into projecting that appellant was a alcoholic gambler and there was a strained relationship. As a result of it, he has committed the murder anta avaru madidare, which is absolutely, this has no foundation. The other document which I have produced before your court as an additional evidence, that additional evidence is nothing but the bank statement of Basavaraj Kattimani, the appellant. And in his statement, it is very clearly showing that he had sufficient money by selling his sugarcane crop to factory. And through that, he has received a lot of money and he was in the process of receiving some money also. Prior to incident also, he had money in his bank account. During the incident also, he had some money. And subsequently also, he had received a lot of money. So question of he being in debt doesn't absolutely arise. This statement was given by the son of the appellant itself. Sir, nodi ee tara nanna tande madidare, why didn't you produce there anta ಹೇಳಿದ್ರೆ, he said I was not aware. So now, my lords, because motive plays a very important role, I have to first discard the motive here. And here I have produced that evidence under that application showing this honorable court that insofar as the debt is concerned, absolutely there was no such problem. And moreover, my lords, somebody would not ask his wife to give the money. And this is a case where somebody has tried to take her, rob her, what do you say? They tried to rape her, and in the process, whether they succeeded or not succeeded, post-mortem report says rape has not taken place, but definitely an attempt was made and stone was smashed and she was killed. And my lords, no eyewitness in this case, so motive is gone. And the only basis upon which the conviction was entered is, according to prosecution, there is an extrajudicial confession by this appellant to one person in the village saying that, see, look, go and see whether people have assembled near my house. He says, why do you want me to go and see? You can directly go and see. No, I have murdered my wife. See whether these people have assembled there or no. Then he goes and sees, and then he says that, look, he has confessed before me saying that he has murdered his wife. But that person, before the trial court, has not supported the case of prosecution. He is so, my lords, even that also goes away. The extrajudicial confession also goes away before the trial court. He has not supported. So the very foundation, every aspect in the circumstantial evidence, each and every chain has to be established. Here, none of the chains are established. Only a preconceived notion that he was a gambler that prejudiced the court, and then they come to a conclusion that he has committed the offense and they convict him for life. So therefore, my lords, prima facie also no case is made out. Therefore, my lords, this is an appeal of the year 2023. Paper book is prepared. If your lordship are willing to take up for final hearing, I am ready for final hearing also. But if it is not going to come up, then kindly consider suspension of sentence and grant of bail. This is my prayer. And insofar as the legal position is concerned, although this judgment would help during the time of final hearing, but because this is a the Supreme Court judgment, four-judge bench judgment, where the case pertaining to circumstantial evidence is very exhaustively dealt and discussed. Four-judge bench judgment of Supreme Court.
Take place?
Incident has taken place, my lord, on
When did the incident take place?
incident has taken place, my lord, on 3/3/2022. And appellant was arrested on 14/3/2022. Initially, complaint was registered under section 302 and 376 rape. Insofar as the prosecution is also alleging that there was a recovery at this base. The murder itself has happened because of the stone, and the stone was lying there itself. So, my lords, a recovery in criminal jurisprudence would be like, suppose if I have the exclusive knowledge about where I've done it, and if I take the police and show it, then it is recovery. If it is from the public place, it cannot by any stretch of imagination considered as recovery. So, recovery theory is also not gone. And insofar as last seen theory, nobody can come before the court and said that I have seen them last together. And even on last seen theory also, the criminal jurisprudence is very clear that it should have proximity with the murder. Suppose if somebody sees together, two people together in the night, if body is found in the morning, then it cannot be said that they are last in theory, because there has to be some immediacy, some proximal time limit. That is also not there here. And very important judgment, which is the judgment, which would eliminate the law on circumstantial evidence, where four-judge bench, Justice B.R. Gawai headed this. Lord Justice Arvind Kumar has authored this judgment. May I, with your permission, present? I will not read the whole thing, my lords. I'll just come to the last paragraph itself. Paragraph 37. Once again, my apologies, I have not numbered
Paragraph?
Paragraph 37, which is on the last page. Last page only.
37 or 27?
Paragraph 37. 37. Last page only.
Yes.
Seen in this background, seen in this background, we need not go further and consider the evidence qua other circumstances sought to be proved by the prosecution, since the failure to prove a single circumstance cogently can cause a snap in the chain of circumstances. There cannot be a gap in the chain of circumstances. When conviction is to be based on circumstantial evidence solely, then there should not be any snap in the chain of circumstances. If there is a snap in the chain, the accused is entitled to benefit of doubt. if some of the circumstances in the chain can be explained by any other reasonable hypothesis, then also the accused is entitled to the benefit of doubt ಅಂತ ಹೇಳ್ಕೊಂಡು exhaustive after going through everything, 4 judge benches come to the conclusion. So here, series of chains have snapped. One, the last seen theory is not there. Motive is not proved. Second, the complainant itself says for 20 years they are happily married and living. The third aspect, my lords, is with regard to my lords, the recovery. That is also not proved properly. The fourth, my lords, the person who says that extrajudicial confession itself is a doubtful picture in the overall scene. But even then, that person also has not come before the court and supported the case of prosecution. So in such a case, absolutely there was no ground for them to convict him. He has already spent 2 years in prison. And my lords, he is the one with the land. He has to take care of his land and agricultural land. He is also, so therefore, my lords, I carve out an exception. If lordship is willing to take a final hearing, I am ready to argue on final hearing also. But if
Only thing we'll have to consider is your additional document.
yes, additional document, additional evidence under 389. That also I have produced.
No, you are now seeking to produce it along with an application.
Application.
Therefore, it is not an evidence as of now.
As of now, it's not
That is why we said document.
document. Oh my.
Huh?
Oh,
So what do you say about this document?
My lords. Shall I brief on that?
Huh?
I'll brief on that.
Alala, we will give a date for considering the appeal on merits. What do you have to say about this document?
Documents which have been produced before the honorable court, my lords.
It's a bank statement.
Nothing was prevented the other side
I- I-
for producing
All right.
and
It was
leading
not
the
produced.
evidence to that particular
All right,
aspect.
it was not produced at that point of time.
Yes,
What is the difficulty in accepting this now?
of course, my lord. So I do agree that there is no bar at all. He can produce it. But my grievance is, my lords, the deceased
So
and
we-
accused own son and daughter.
We will consider the matter on appeal.
Yes,
We only wanted to know what would be your objection for this
Yes, 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 ma'am.
document. If you say, all right, let us consider this along with the main matter.
Yes.
We will hear the matter next week.
please.
I'm good.
Huh? Because going by what is stated now, it doesn't look like there is a elaborate arguments required
Arguments are
in
not
this matter.
Elaborate.
We will
document
consider,
is-
we will consider.
Yes, ma'am.
We are of the opinion that it can be disposed of. Appeal can be disposed
Only
of.
my submission would be, my lord,
Yes.
the accused own son and daughter has supported the case
Aye,
of the
ade.
corruption. And I'll
The
elaborate
details,
to,
the details and your objections will
Yes.
be heard.
yes.